When the defense attorney turned to me during a pretrial conference while we're waiting for the judge in court and said, "You and I both know what the true value of this case is worth. So let's just cut out the nonsense and you tell me what will it take for you to settle this case?" I said, "I'm happy to share that number with you as long as you tell me exactly how much authority and how much money you have right now in order to settle this case." You want to know what happened? Come join me for a walk through the neighborhood as I share with you exactly what happened. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. I'm sitting in court waiting for our case to be called for a pretrial conference. This was a medical malpractice case, and my adversary and I were on friendly terms. We were professional. I had known him for a long time, and this was not the first case we had handled together. Now we're sitting in court. We had not had any detailed settlement conversations before. And now, if we were unable to settle this case, the judge was going to give us a trial date that likely would take place within the next month or two. Now, at this point, before we go and see the judge, we're waiting in court. There must be about 50 to 100 other attorneys in court also waiting to see the judge. While we are sitting there talking, now the defense attorney turns to me, as often happens, and says, "Listen, what do you say we try and negotiate this case without the nonsense of you making an outrageous demand and me giving you a low-ball offer?" I said, "That's fine. So tell me how much authority you actually have." And instead, he turns around and says, "You tell me exactly what it's going to take to settle this case." So now we're at a bit of a standoff. He wants to get intel from me about exactly what I need, my bottom line number is to settle the case. And I want intel from him about exactly how much money he has in his pocket, figuratively, from his insurance carrier, that he's willing to offer right now, the maximum amount that he has authority to go ahead and offer, so that now we get a good understanding of where we are. And now when we go in front of the judge, we can have an honest explanation, an honest discussion about how much money has been offered and how much we need to go ahead and settle this case. However, there are significant drawbacks to having this type of conversation with an attorney, especially an attorney whom you do not trust, or whom I do not trust, or I don't know. Why is that? So let's say he turns to me and says, "Listen, give me your bottom line number of exactly what it's going to take to settle this case." If I were to go ahead and tell him hypothetically that I need $1 million as my bottom line number to settle this case, do you really think he's going to turn around in the same breath and say, "No problem, here's $1 million. Case is now settled"? The answer is absolutely not. So no matter how good intentioned he may be, no matter how nice a guy he may be, no matter how earnest he is to try and resolve this case early during this pretrial settlement conference, the moment I give him what I tell him is my bottom line number, there is often no possible way he's going to come back with that number. Why? Because whatever number I go ahead and lay out for him as my bottom line number, he's now going to think that he needs to approach that or get close to that in order to settle the case. And that is why it is a very, very dangerous strategy to go ahead and disclose my bottom line number to my opponent, even if he were my good friend. Why? Because I know he's going to take that number back to the insurance company, and now they're going to use that number to go ahead and use that as the highest amount possible that they will ever go ahead and give, which they will not do voluntarily. They may get close to it, and they may make a substantial offer that gets near it, but in all likelihood, they are not going to get that exact number. Now, I could give him all sorts of conditions and caveats, meaning I said, "Listen, I'm going to give you this number, and under no circumstance will I take a dime less. And if you come back with a dime less, we're trying this case. I don't care whether it's over $10, $10,000, $50,000. I'm going to have to try this case if you come back with anything less than that." So now I'm taking a gamble. I'm taking a very big gamble if I go ahead and disclose my bottom line number to him. And it's very dangerous for me, because if he goes back, he's going to say, "Listen, is there any way we can save money on what we offer?" And if he goes ahead and saves money on this particular settlement, he's going to look like a hero. And now there's a good chance that his principals will give him additional work, additional cases to work on for further business. So he has an inherent interest to make his principals happy by saving them money on this particular settlement. My goal is just the opposite. My goal is to get as much money as possible for my client to compensate him for all of the harms and losses and damage that he incurred as a result of this wrongdoing. So now let's get back to the question I raised at the very beginning of this video. We're in court, we're waiting for the judge to call us for a pretrial settlement conference, and my opponent says, listen, what's your bottom line number that you need to settle this case right now? And instead, I say, listen, I need you to tell me how much money, how much authority you have to settle this case. And it's almost as if we want to do it at the same time and to hear what each other has to say, because they will be very, very different things. If I need $1 million, I can't tell him that I need $1 million and not a dime less. I may have to tell him I need $1.5 million, but I have some flexibility. He may come back and say, listen, I have $750,000, but I have some flexibility. This way now, each of us have the ability and wiggle room to come up or to come down. That is a much better strategy than for me to go ahead and say, listen, I need $1 million, and now he comes back and says, okay, here's $800,000, that's the end, that's all I have, nothing else. Now he knows what my bottom line number is, now I know what their top number is, and there's no way we're ever going to bridge that gap, at least not voluntarily. So why do I share this settlement discussion with you, this settlement strategy? I share it with you just to open your eyes, because these types of conversations happen on a regular basis in these medical malpractice cases in New York. Now, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter has happened in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You should know that I don't get involved in cases that have already been started, and I can't go ahead and give second opinions on your case that is ready for a pretrial conference and you've been offered a particular amount of money. And you might be saying, why not? Why can't you do it? Because for me to give you an educated opinion about whether or not I think your case or your settlement offer is appropriate, I would have to know every single detail of your particular case. That would mean a significant investment of time, of learning every single detail about your case, having access to every single document, knowing everything that happened over the past 2 years. And that's not a realistic expectation for an attorney who doesn't even know any of the details of your case. So if you have not yet started a case but are thinking of doing so and still have questions, I invite you to pick up the phone and call me. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.